Suzy Rhoades here with PassMasters, here again for this week's Questions of the Week. This week, our topic is communication with clients, customers, and prospects. You can expect this topic to appear on your Series 63, 65, and 66 exams. We will be taking a 20-question topic quiz from within one of our PassMasters online securities courses. Let's check out our learning management system. Under the marketing rule, an advertisement may include the presentation of performance results. Which of the following are true regarding these results? Roman numerals 1 through 4. Quick scan of all the answers. There's no giveaways, darn it. 1. They must be recent, ending on a date that is no less recent than the most recent calendar year end. 2. They must include results for 1, 5, and 10-year time periods. 3. The time period requirement only applies to gross performance. 4. The time period requirement applies to both gross and net performance. 1 is true. The performance results must be no less recent than the most recent calendar year end. So 1 is true. You can get rid of one of your answer choices. 2, they must include results for 1, 5, and 10-year time periods. That is true. 3 and 4, it's not possible for them both to be true. So 3 is false. The time period requirement applies to both gross and net performance is true. 1, 2, and 4. So you choose what you believe is the correct answer. Click check answer. You know you got it right if you get that green check mark. You can click show explanation to read the explanation, and you can listen. So there I am. All of our questions in our courses have audio explanations. When an investment advisory firm charges a wrap fee, they must give out which of the following disclosure documents? Form ADV Appendix 1, Part 2A, Part 2B, or Part 1? It is Form ADV Appendix 1 that is required anytime an IA charges a wrap fee. Which account has required documentation that must be received prior to any trading in the account? Discretionary account at an investment advisor, margin account, discretionary account at a broker-dealer, or options account. So required documentation that must be received prior. Discretionary account at a broker-dealer. There can be no oral discretion at a broker-dealer. In general, when is a communication considered an advertisement under the marketing rule? When it offers the advisor's investment advisory services. When it is directed to a current client. When it offers the advisor's investment advisory services with regard to securities, or when it is directed to a prospective client. So it doesn't matter if it's a current or prospective client, which leaves us with 2 choices that are very similar. The correct answer is the most correct answer. When it offers the advisor's investment advisory services with regard to securities. Juan is an agent in Arizona representing broker-dealer XYZ. Which of the following statements could Juan legally say? Roman numerals 1 through 4. 1, I am registered with the state of Arizona as an agent. That seems like something Juan could legally say. 2, I am registered as an agent of XYZ broker-dealer. Yeah, he can say that. So 1 and 2. We've only gotten rid of one of the answer choices so far. 3, I am an approved agent in Arizona. Does the administrator ever approve anybody? Never. So 1 cannot say 3. So you have to get rid of anything that has 3 in it. 4, the Arizona Securities Administrator has endorsed broker-dealer XYZ. No way. The administrator does not approve or endorse anybody. So the two that are correct, Roman numerals 1 and 2. A broker-dealer is going to raise its service fees for all clients, as well as introduce some new fees. Which of the following is correct? No notification is required. Clients must be sent a letter via first-class mail to the address on file. Clients must be notified in writing at least 30 days in advance of the increase. Clients must be notified within 30 days of the increase. Clients must be notified in writing, and electronic is okay, at least 30 days in advance of the increase. Which of the following would be attributable to the advisor under the marketing rule? Social media postings to associated persons' own accounts, marketing the advisor's advisory services. Let's see. Social media postings to associated persons' own accounts? No. Permitting the use of like, share, or endorse. Or social media comments that are edited by the investment advisor to remove profanity. Which one would be attributable to the advisor under the marketing rule? Social media postings to associated persons' own accounts, marketing the advisor's advisory services. May a federally registered investment advisor include performance information in an advertisement? No. Yes, if certain conditions are met. Yes, if they have over $200 million in assets under management, or yes. There are some rules that must be met anytime an advertisement includes performance information. The marketing rule applies to federally registered investment advisors. The most correct answer here is yes, if certain conditions are met. Requirements that must be met if an investment advisor chooses to deliver its brochure and brochure supplement electronically include which of the following? Roman numerals 1 through 4. 1, the firm must have procedures to supervise personnel transmitting the brochure and supplement electronically. True, yes, 1 is part of the correct answer. You can get rid of 2 of the choices. 2, the client must give prior consent to the receipt of the brochure and brochure supplement electronically, with the exception of initial delivery. 3, the electronic brochure and brochure supplement must follow the format required for Form ADV Part 2. Yes. 4, for initial delivery, the firm must receive from the potential client verification that a readable copy of the brochure and brochure supplement were received by the client. All 4 of those choices are correct. Roman numerals 1 through 4. An advisor states in an advertisement that it has more than 100 clients that have stuck with me for more than 10 years. Under the marketing rule, which of the following is true? This may create a misleading implication, which is prohibited. This is a legal statement. This is considered a misleading statement, or this is not considered a misleading statement. Under the marketing rule, this may create a misleading implication, which is prohibited. Which of the following are agreements that must be signed by a client when opening a margin account? 1, margin agreement. Yes. 2, risk disclosure document. 3, hypothecation agreement. 4, loan consent agreement. The risk disclosure document must be given but is not signed by the client. The hypothecation agreement must be signed by the client. The loan consent agreement, even if not signed by the client, will still be something that the broker-dealer does. loans out the securities in the margin account to others. So which of these must be signed when opening a margin account? The margin agreement and the hypothecation agreement, 1 and 3. In which of the following situations is the investment advisor required to deliver a brochure and related brochure supplements? 1, to clients who receive only impersonal advice and who pay less than $500 in fees per year? No. 2, to clients who receive only impersonal advice and who pay $500 or more in fees per year? 3, to clients that are investment companies registered under the Investment Company Act of 1940. Or 4, to clients who receive personal investment advice, regardless of how much they pay a year. So definitely to 4, but it's also true, number 2, that if clients receive impersonal advice and they pay $500 or more in fees per year. 2 and 4 are the correct choices. Cherry picking of past investments for an advertisement of an investment advisor, that would be just picking the good ones, is prohibited, allowed, permissible with proper disclosures, or advisable. Cherry picking is prohibited. The investment advisor sponsors a wrap fee program. Which of the following is true regarding this firm's brochure? They must prepare both a regular brochure and a wrap fee program brochure. They give out the same brochure as any other investment advisor. The wrap fee clients must receive a wrap fee program brochure, which is Form ADV Appendix 1. This brochure must be updated quarterly. No. The only one of these that is true. The wrap fee clients must receive a wrap fee program brochure. It is Form ADV Appendix 1. Regarding the investment advisory firm's brochure, which of the following is incorrect? The firm's Form ADV Part 2A can be given to clients instead of a brochure. That is true. It would be really boring and hard to read, but it is true. It must present required information in a specific order. Very much true. It must be written in plain English. True. It must be given in person. False. That is incorrect. Investment advisors must keep advertisements for 3 years, 5 years, 2 years, or the life of the firm. Investment advisors' books and records rules require them to keep books and records for 5 years. That includes advertisements, 2 years readily accessible. Under the Investment Advisors Act of 1940, which we know as federal securities law, which of the following are allowed in advertisements? 1, the use of testimonials. 2, representing that one chart or graph can be used to decide which securities to buy and sell. 3, referring to past recommendations made. 4, stating that an advisory service will be provided for free when there are no strings attached. The Investment Advisors Act of 1940, I said, was federal securities law. The marketing rule applies to federally registered investment advisors. All of these are allowed in advertisements today. Not necessarily for state registered investment advisors, however. Under the Advisors Act marketing rule, private placement memoranda are considered testimonials, are considered endorsements, are included within the definition of an advertisement, or are not included within the definition of an advertisement. Private placement memoranda are not included within the definition of an advertisement. An agent can promise to a customer that they will resell a security at a higher price than that paid by the customer. What? Never. With written permission of the client, if the client has been with the firm for at least 2 years, or with approval of the firm. Never. Definitely you cannot do that. SIPC would provide coverage for which of the following? SIPC is the Securities Investor Protection Corporation. Roman numerals 1 through 4. 1, U.S. government securities. 2, stock in a brokerage account. 3, cash in a sweep account. 4, decline in the value of investments. SIPC never provides coverage for a decline in the value of investments. It covers securities that are at a broker-dealer when the broker-dealer goes broke. Roman numerals 1 through 3 are covered by SIPC if the broker-dealer goes broke. That's it for this week's Questions of the Week. Our topic was communication with clients, customers, and prospects. It's a pretty big topic on all of these NASAA exams, so you want to do well here. If you have any questions at all, just ask me in the comments below. Be sure to give this video a thumbs up, subscribe to our channel, and turn those notifications on. If you would like to check out our PassMasters course offerings or to enroll in any of our programs, there's a link found in this video's description. Keep up the good work. I hope to have you as a student soon. Happy studies.
You got this.